Hey everybody, thank you for coming today. Glad you could all make it through Comic-Con. And I'm surprised this is how you're spending your last hour here, being educated, but hopefully we'll be a little entertaining as well. Just a little show of hands, the people in the room. How many writers do we have here? About comic book artists? Not regular artists? The rest of you. Couldn't get into the William Shatner Q&A, right? Neither could I. So, first thing, little thing that I want to tell you, and it's our big little warning that starts this thing, and because we are attorneys, there's always a warning. And this panel today and everything in this panel is for educational and informational purposes. We're attorneys, but we're not your attorneys. So if you have a great idea for a comic book character, don't shout it out in the room. If you committed any major crimes, don't let us know. If you have a meth lab in your basement and you want to open a car wash to cover it up, don't ask Meredith how to do that. She's not going to tell you. First of all, who am I? My name is Michael Lee. I'm an attorney. I specialize in what people call entertainment law, which is kind of intellectual property law. Whether to do with copyrights, trademarks, I do registration, licensing, enforcement, lawsuits, all that fun stuff. I also have a blog. It's www.piratedthoughts.com. And on the blog, I just blog about the interesting aspects of sci-fi world, of the comic book world as pertains to IP law. And you can follow me on Twitter, Emily Esquire. Oh, and by the way, if you're me, Michael Lee, try to get your name on Twitter. About 1 billion people in China got before I did, so I was very late to the show. I'm here with Meredith Mazzola. Meredith is also from my firm, and she's in the emerging business practices group at my firm. She does a lot of work with up-and-coming corporations, whether it be incorporating, taxation, and also Meredith does wills. So in case anybody here plans on dying this weekend, Meredith is here to help you out. And Meredith, who got her name on Twitter, Meredith Mazzola, of course, just joined, so go ahead, follow her. She needs to follow herself.
Yeah, I got it before. I joined yesterday.
Yeah. So I've been doing this for 4 years now, and over the last 4 years, people have asked me a lot of questions, and this year I tried to focus the panel on things that you need to do to protect yourself. If you're an up-and-coming business, if you're an up-and-coming artist, we're going to talk about the things that you need to do to protect yourself and make sure that everything you do is right and correct, and you don't wind yourself up in some trouble. So what's on the agenda? First, Meredith is going to come up and talk about business formations and why it's important to form a business. And then I'll get on the mic again and we'll talk a little bit about why it's so important to register your copyrights and register your trademarks. If you're an artist, you have to do this stuff, and we'll tell you the reasons why. We'll talk about the things that will get you sued, and hopefully maybe you could do a little suing if somebody's using your work improperly. And finally, we have a Q&A. We plan on speaking for about a half hour. But you know, lawyers, we tend to be a little wordy, so we might go a little longer than that. And then we'll open up the floor to you where you can ask any questions you have and get some free legal advice. Don't ask about pending divorces because we don't know anything about that. But all right, so I'm going to turn over to Meredith, who's going to talk a little bit about businesses.
All right, hi everyone. Michael is very experienced. This is how many times you've been here?
Like 20.
20.
4 plus about 4 in Chicago.
Yeah. This is my first, so don't, it gets better. All right, so Michael did a great job of laying out what we're going to do, and the first thing we're going to talk about is business formation. But even before that, because I'm actually a really big nerd, aka a tax lawyer at heart, we're going to talk about whether you have a business for tax purposes. I'm going to start off with an example of Han Solo. So long before meeting Luke Skywalker or saving Princess Leia, he was a smuggler, and he drove the Millennium Falcon. When he went to purchase the Millennium Falcon, there was a question of whether he could deduct that on his taxes against his other income. So in order to do that, you have to have a trade or business, and the expense has to be an ordinary and necessary expense of that trade or business. In order to determine whether Han Solo had a trade or business, the question is whether he had the primary motivation of making a profit. That's an easy one. I'm not really sure anyone would have been a smuggler if you weren't going to make money doing it. On the other hand, let's think about George Lucas. So back in the 1960s, he made a series of small films, or short films. And who's to say whether he wanted to make money and knew that one day he'd be who he is today? And in that case, the IRS or state government might say, no, you can't deduct those expenses. Now, the second issue is whether it's ordinary or necessary. The Millennium Falcon is arguably the fastest, most reliable spacecraft out there, and Han Solo needed that in order to have a successful smuggling business. So we would say yes, he could deduct that. Honestly though, it would probably be, there's two issues. One, it's a capital asset because it's something he's purchasing that's going to have value for a number of years. And then he'd have to deduct it over time. And also if it's what we call a luxury vehicle or spacecraft, he'd have certain limitations on that. Again, going back to George Lucas, in that 1960s period when he was probably losing money making films, after 8 years, the government says, no, you can't deduct these expenses anymore. You have a hobby, not a business. George Lucas didn't have to worry about that though because, well, we all know what happened. Okay, so, I know, there he is.
Hi, hello.
All right. Except now I'm stuck up to it.
It'll take us. There.
There we go. Okay, so now shoot forward 1971, and George Lucas has now already worked with Francis Ford Coppola, and he's making American Graffiti and Star Wars. So what does he do next? He forms Lucasfilms. So he knew what was up. He knew he had to form a business entity. And so why? Why do you form a business entity? Well, number one is to protect your personal assets from liability. If you enter into a contract, and that contract is in the name of the business, and you do everything according to the letter of the law, they cannot go after your personal assets if there's a breach of contract claim. So that's number one. Two, the business entity allows for ease of operations and growth. So you may want to take on investors or partners, and having a business entity allows you to do that much easier than if you were on your own. And finally, it's just a method of having centralized tax and accounting. So you keep all of your business expenses and profit in one section and your personal in another. Okay, so what kind of entities are there out there? Some of you right now are operating as what we call sole proprietorships. So it's just you, you're a one-man show, you collect all the profits, everything is just you. However, if maybe you have somebody else you work with, you're defaulted as a partnership, even if you haven't formed an entity yet. Now, two entities I want to talk about is corporations and limited liability companies, because they're really the most advantageous for most businesses. Corporations can be C Corps or S Corps, and I'll talk about that in a minute. That's their tax election. And they're organized by shareholders who are the owners, directors who are the supervisors, and officers who are the day-to-day managers. So LLCs, on the other hand, the owners are what you call members, and the members can really do anything they want at that point. They can have different terms of management, they can have different terms of profit and loss splits. It's really very flexible. So, we'll get to that in a second. I'll tell you the real quick tax pieces. So corporations can be taxed as a C Corp or an S Corp. And C Corps are taxed twice. They're taxed at the entity level and then again to the shareholders. But you can make an S election in which then you're only taxed once, and that's to your individual, the shareholder. Now, there's certain limitations. You can only have up to 100 shareholders, which for most of you guys in here, I think we're pretty okay with that at this point. If you're going to get bigger than that, you've got to go bigger. But the one thing that might affect some people is you cannot have non-resident aliens as shareholders. So if you have investors or partners that are not U.S. persons, then that's an issue. And then an LLC can be taxed in a variety of ways. It's either taxed to it's called a disregarded entity if you're a one-person LLC, single-member LLC. It can be taxed as a partnership if you're a two-member LLC, or you can even elect to be taxed as a corporation, but honestly, that's not recommended. So now we're going to get to this slide. Sorry, I've jumped the gun on it. And the first thing we're talking about is, okay, so you decided let's form a corporation, not a limited liability company. the first thing you're going to want to do is pick a name. So you will, search your business portal. Every state has one in order to pick a name. Michael will talk about later. You cannot use a name that's a trademark name, so you can't use Lucasfilms. And then you're going to pick a state to form in. You want to pick the state that you operate in, honestly. So, or if you operate in multiple states, you can pick one of them and qualify to do business in another. And then they do a bunch of paperwork, which is what you come to us for. We're really good at it. It takes like 3 days or less if you're in a very big hurry. And so you give us all the information, who are your owners, how, what state you're operating in, and that's basically it. In 3 days, you formed your corporation. Earlier I mentioned that the reason you're forming this business entity is to limit your liability. In order to do that, you have to follow certain corporate formalities. So things like you have to have shareholder and director meetings. Those shareholders and directors have to approve major, say, acquisitions of another company, acquisitions of real estate. There are certain things that have to be followed. If you don't follow these corporate formalities, you lose that limited liability. All right. So now that we've talked about how you form your C Corp, or any Corp, like I said, you could actually make it an S Corp and have pass-through. There are advantages and disadvantages. So the advantage, this is the cheapest entity to form. This is a couple $100 in state fees and then a couple $100 in legal fees. They're talking very, very cheap. You can also have preferred stock. So if you have investors or people who are putting in capital, they may ask for what's called preferred stock in order to get back a return on their investment. You can have an initial public offering from this type of corporation. So if you really hit it up big, you're gonna, Facebook's big, you can have an IPO. You can offer equity ownership. So this would be if you decide to take on somebody maybe as your artist with your comic book, and you created the comic book, but he's creating the artwork. You can offer him stock options, which would be how he would get paid, and even if you're not paying him currently a salary. Okay, some disadvantages. It's very limited. Like I said, you have shareholders, you have directors, and you have officers. There's no way to structure this. It's 50-50 people, if you put in capital, 50-50, your profits coming out are 50-50. With the exception of, like I said, preferred stock. But for the most part, this is how it is. So you have to follow corporate formalities, and there is double tax unless you qualify to be an S Corp. Okay, so then maybe you don't want a corporation because of those reasons, and the other option would be to form a limited liability company. The limited liability company, all the same things you do for a corporation. You have to choose a state to operate in, pick a name, but then now you have articles of organization, which is how it's going to structure your management and profit and losses. And that's where the flexibility comes in. So you may have, for example, a colleague that wants to split the startup costs of the entity, and then, well, their panel is so much better. Okay. Yeah. So you can have two people who want to share the startup costs, but only one of them is going to operate the business. That's fine with an LLC. No issues there. You could have where somebody wants to share in the management, but doesn't have any money to put in. Totally fine with an LLC. So like I said, there's tons of flexibility here. So advantages, disadvantages. Pass-through tax treatment is always an advantage. Nobody wants to pay tax twice. Flexibility in operations. So disadvantages, investors don't always love this form of entity. So if you are somebody who thinks that your business is going to grow by capital infusion of angel investors out there, it might not be the way to go. And the second disadvantage that is quite large is, especially in New York State, the fees are much higher to form. So you have to do a publication fee, which is a couple $1,000. That adds a significant cost over forming a corporation. All right, so you've decided on what you want, whether it's an LLC or a corporation. What do you do next? You need a tax ID number. You'll want to open bank accounts in the name of the business, negotiate any leases and sign any leases in the name of the business. Depending on what you're doing, you're going to have to obtain various forms of insurance. You'll want to secure a domain name, prepare employee contracts, work for hire contracts, and lease any necessary equipment. And I know that it's funny, we spent so much time on the first part. This is actually what's going to take you so much longer. The first part we're all doing in, 3 days to a week. And that's pretty much how you start up your business. I'm so happy to speak here at Comic-Con, and Michael is going to take you through, now that you have a business, what to do with your trademarks and your, protect your property rights.
Must be on your phones looking at something else.
Yeah.
I don't know what you're doing here. So now I want to talk about a little bit about your IP. Now, as Meredith talked about, you can have a corporation, but you don't necessarily have to have a corporation to protect your IP. You can do this by yourself, or the way that I prefer that you do it is in the name of your corporation. And the reason why is because you do not want to get sued individually. If I'm going after somebody who is stealing some of my client's work and their name is actually registered on the trademark, I will sue you personally. You'd rather have somebody sue your corporation than you would you personally. So the first thing we're going to talk about is copyright. And copyright is what a lot of people know about and everybody knows about. It's the more familiar kind of IP. It's protection that's invoked as soon as something is permanently fixed in a medium. It's when you take pen to paper to something. As soon as you get something on a piece of paper, as soon as it's permanent, you have copyright protection in it. Now that's not the same as a registration, and we'll talk a little bit about why you want to register things, but you have copyright protection in something as soon as it's fixed. And we all know it by that C in the circle in it. That's the common symbol for copyright. Things that are copyrighted are things you know about. Books, and that includes all the words and the language and everything in the books, but also comic books. And when looking at comic books, here's a little difference between copyrights and trademarks. Things in The Amazing Spider-Man, the comic book. The things that are protected by copyright are the look of everything, the plot, the script, the dialogue, things like that are all protected. Things that are not protected by copyright are titles, like The Amazing Spider-Man is the title, but it's also the name of a character. Short words, phrases are not protected as copyright. You cannot register a copyright, although those could be trademarked, and we'll talk about that a little bit. Now, when we talk about something being fixed in a medium, that medium does not necessarily need to be paper. It could be paintings. As soon as you take your paint and you put it on a canvas, you have a fixed copyright in that. It's protected. It can also put things like sculptures. Anything that's permanent, it could be kept in. The immortal music of Justin Bieber. It's going to be protected for all time, so you can't steal that. That's true. You can probably do a better job than he does. What's protected is also the melodies, the tune, the lyrics. You have certain rights to perform that, and we'll talk a little bit about fair use. But actually, Justin Bieber, well, whoever writes it actually has the rights to protect it. So. Finally, photographs. The medium that has to be fixed in is not necessarily one that has to be down on paper. It could be your phone. As soon as you go out there and you take a photo, it's captured permanently on your phone. You have copyright protection in it. That's how easy copyright is. It's a very minimal test. Other things that are protected, movies. The structure, the plot, dialogue, characters, all things that are protected. Another thing that's not protected, though, is remember the title. So the name Halloween is not protected under copyright, but it's a protected trademark. Architecture, and this comes into a big issue with comic books when you draw them, and somebody shows a picture of a building in the background. You know what? A lot of that stuff is protected under copyright and trademark. So the question is, are you allowed to do that? And we'll talk a little bit about fair use and whether that's okay. But architecture is also something that's protected in copyright. Things like software. The fixed medium there is the source code, and source code is protected, and it's also a big pain in the neck to register for copyright because you're required to, file the source code with the Copyright Office. But that's something that's also protected. The big one that most people come to me now with are apps. You create your own app. Yes, apps are protected under copyright. The look of it, the feel of it, some minimal aspects of what's done in there, but apps can also be protected under copyright. And labels, things like commercials, cigarette labels, things that you wouldn't ordinarily think are protected, those are actually protected under copyright. So you can't really do, and I think this is probably not even real. I found this on the internet, but it was pretty cool. Those Absolute Vodka ads, those things are protected as copyright as well. Now, the most important thing I could tell you today is if you're an artist, you have to register your copyrights. The first reason why is it establishes a public record of your claim. You want everybody in the world to know that you created something, and you don't want anybody else to come along and take it from you. Second, it's prima facie evidence, and this is a fancy legal term, but it means on its face. So on its face, everything in that copyright registration is taken as true. It's taken as true that you're the owner. It's taken as true when you created it. So if you have a registration, everything that's in that registration is taken on its face to be true. It protects against imports and exportation. And this is an important thing. It came up last week for a client of mine who does jewelry. And somebody tried to import look-alike jewelry. Customs, the actual US Customs Immigration, seized a bunch of copyright infringing bracelets. So if you have a copyright registration and if you're into designing certain clothes or jewelry, you could protect people from bringing illicit items, usually from China, into the country. It's a prerequisite for certain damages. It's hard to prove damages if somebody steals your work. Okay, yes, if somebody takes your stuff, makes a movie out of it, you get to kind of figure out what the gross is on that movie. But a lot of times it's very hard to do. And what the Act provides is for statutory damages. And it goes up to $150,000 per work. So if somebody takes your work and you're unable to prove actual damages, you could request statutory damages. You could also get your attorney's fees as part of that. You cannot do that if it's registered. And finally, it's necessary to commence a lawsuit. There is no other way around this. I don't care if somebody breaks into your house, steals what you did, and gives it out in Times Square. If you do not have a copyright registration for it, you cannot sue them for copyright infringement. Now, somebody's going to ask, because it happens every year, well, what about poor man's copyright if I mail it to myself? Or what if I registered my script with the Directors Guild or the Writers Guild? That stuff really means nothing. What you have to do is register your copyrights. So those are some of the reasons why you definitely want to do it. Now that you have your copyright registration, now you want to know how to do it. And this is something that I really recommend you do yourself. Of course, you could pay somebody like me to do it for you, but it's really something that you could do yourself. First, you go to the forum, and the website is copyright.gov. But here's the problem. Because of the government shutdown, the website no longer works. So there's going to be a lot of backlog on copyright registrations when we finally get going again. But if you go to copyright.gov, you could go and download the form. That's it. It's a little piece of two-sided paper. It's not very impressive. And that's all you do is fill it out. There's some couple questions about it, the name of the title, who created it, when it was created. It's so really easy to do that you can do it yourself. The second thing the government wants is the deposit material. And they're very explicit about what they want. They tell you what they want. If you're protecting a photograph, of course you submit a copy of the photograph. If you have a movie, you might want to submit a DVD of the movie, but you also might want to submit your script. It's that easy. So they just want to know what's being protected as the deposit material. Third, of course, the government wants your money. Right before I tried to check right before this panel started, but it didn't. This website still doesn't work. If you do so online, it costs $35 per copyright registration. And here's the thing, you could put a series of things on one copyright registration. So if you have series 1 through 7 of your comic book series, you could put those on one registration to save yourself a lot of money. If you do it the old-fashioned way, which takes a lot longer, I think it's up to $55 that they do charge you. So the best way to do it is online, it's quicker, and especially in cases where if there's a rush to file, let's say you find out somebody is stealing your work and you haven't registered that copyright, if you want to sue them, if you're not registered, you can't sue them. So it's much better to do it online. Now, you have your copyright, what do you get? First, you have the right to reproduce. You're the only person in the world that can make copies of what you made. Nobody else can do so, and that's a very strict right. You have the right to prepare derivative works. So if you have your comic book, you're the only person in the world who can make a movie out of it. If you have your comic book, you're the only person who can make action figures out of it. All those things are called derivative works, and nobody else can do that but you. You have the right to distribute copies. You're the first person that decides when your work gets put out. Once it's put out, though, you lose most of your rights to control what's done with it, unless it's sent out by license, but you're the first person that decides when it does get put out. You have the right to perform. If you write a play, nobody else can perform that play without your permission and paying you a licensing fee. You have the right to display. If you create a work of art, only you could decide where it hangs. Nobody else could take it and hang it anywhere else. And you have the right to perform digitally. So all this stuff can be done online. If you want to put your movie on YouTube, you can, but nobody else can. So we take all those rights, we put them in together in a big bundle, and it's called the bundle of rights. Now you could do whatever you want with those rights. You could keep them for yourself, you could license all those rights away, or you can even sell your rights to the copyright. So that's why a lot of different companies have movies, but they have licensing companies. It's because they've licensed out some of these rights. And so those are the rights that are granted by copyright. Now, some quick reminders based upon questions that I've gotten over the last 4 years of doing this. How long does copyright registration last? It's the life of the author plus 70 years. If it's a work for hire, which maybe hopefully we'll have enough time to talk about, it's 90 years or 120 years from creation, whichever expires first. Important thing to remember here is these dates always get lengthened. And why? It's because Walt Disney has great people in Washington who back them up, because Mickey Mouse every couple years is about to fall into the public domain. When something falls into the public domain, anybody could take it and do whatever they want with it. A good example about a case that was actually filed this week has to do with L. Frank Baum's The Wizard of Oz, which was released in 1900. Anybody can make a movie based upon the book because it's in the public domain. So those are the times, but in another couple years when Mickey Mouse is again about to fall into the public domain, they'll magically be lengthened again. Fan art, fan fiction, all that stuff on Artist Alley. Guess what? That's copyright infringement. A lot of people don't want to talk about it, but it is. Do you have permission to reproduce that stuff? No. The question is, though, is it fair use? And sometimes it's fair use, sometimes it's not. If you do a couple one-offs, maybe it's okay. If you go on the internet and try to sell copies of your art, you might run into a little problem. And when to register? Register before it's published, before it gets out. That's what I recommend. Or if not, hurry up and register. Because if somebody is out there using it, you have to register within 3 months in order to get certain kind of damages, those statutory damages that I talked about earlier. And you could, remember I talked about the transfer. You could transfer any rights, all of your rights or none of your rights, but if you do that transfer, it has to be in writing. A case was decided this year that writing can even be an email. So if you want to transfer the licensing rights to your copyrights, you could do it in email. And the big one here is if it's a transfer of rights, it may be terminated. This is the crux of a lot of the lawsuits out there with Siegel, with Stan Lee, with everybody else, is whether there were work for hires or whether they were actually copyright transfers. So after 56 years, there's an automatic right to cancel that transfer. So those are some of the quick copyright reminders, and now we're going to talk a little bit about trademark. Trademark is a symbol, a word, logo, device, anything that's used that you automatically associate with a person, a product, a service. Now they have two symbols, TM with the circle and R in the circle. TM just means it's a trademark. R with the circle means it's a registered trademark. Much like you register the copyright, it's very important to register your trademarks, and we'll talk a little bit about why. The first thing that we could think about trademark are logos. As soon as you see those, as soon as you see that apple, you know what that's associated with. You know the product is associated with. One of the best examples I could come up with is that little Nike swoosh. Whenever you see that little swoosh, if you put that on a shirt, you automatically know that's a Nike shirt. You don't even need to say the word Nike. So it's gained trademark status. Now, the logos do not have to be complicated. You look at some of these designs, which are all protected trademarks, they do not have to be that complicated. And for my blog, and just because I have a lot of time on my hands on the weekends, I troll the USPTO website to find some strange and unusual trademarks. And just to show you how easy it is to get a trademark, this is the badass clown. I don't know what makes him the badass clown. I've seen a lot scarier clowns than that. But this is the badass clown. It looks like it was drawn by a 5-year-old. But this is a protected trademark. It's protected for a line of clothes. I don't know whether it's out or not, but that's it. But that's how simple the logo even has to be. That's it. And they have a trademark for it. Other things that trademarked are unique words, words that don't make sense until you associate them with a product. Like Xerox, you don't know what that's just a word, but now we all know it means to make a copy. Google, we know it means to search the internet. And also names, very unique names, not John Doe, not Jane Smith, but unique names like Indiana Jones, Chewbacca, things like that. And one of the greatest names that's actually trademarked is the word superhero. That's a joint trademark owned by DC and by Marvel. Essentially, if you go and call your character a superhero, you're committing trademark infringement. There's an artist right now that is fighting this, and he's trying to get this word taken out. Maybe, we all know the word Kleenex to be associated with the tissue, but it's lost its cachet as a trademark. So that's what this artist is trying to say, that superhero has lost its cachet as a trademark, and everybody uses it as a common word. Twitter is also scared that the word tweet is about to lose all of its cachet and become a trademark. So that's something that when they decide to go public, they said that's a big worry for them. But unique words, names, can be trademarked. Now, for my site, I wanted to have a Halloween thing, and I looked Halloween. I searched, I swear this is how it happened, I searched the word pumpkin on the USPTO. All right, I might put up to some nefarious purpose, but we're not going to talk about that. And the thing that popped up were pornkins. I had no clue what a pornkin is, so I decided to go to Google to image search that. Yeah, I probably shouldn't have done that at work. A pornkin is a stencil that you put on a pumpkin, and you can carve that out, and when you take off that stencil, you have an adult little scene. They're very disgusting, they're also incredibly funny, so if you want to go look at them, can. But you'll see that little R with the circle, that's a registered trademark, pornkins, and pornkins.com. That will definitely get in trouble with your IT guy at work. So. Other things that could be trademarked, and we think about it in the copyright sense, but also the look of characters. The little boxes in white are actually what's registered with the trademark office. I never knew the Geico Gecko was a protected trademark until I actually started doing work for them this week. They have a problem with people doing incredibly disgusting stuff to that cute little guy. So that's a protected trademark, but it's protected under copyright, but it's also protected under trademark as well. So the look of things, and you usually see when people file trademarks at the trademark office in black and white. That's if there's a slight change in color, they just don't want to have to redo it. But also the look, the appearance of things can be trademarked as well. Finally, catchphrases. Dope. That's a protected word. It's one word, and it's protected by Fox. So if you put that on a t-shirt, you might get in trouble without permission. Coulson Lives is a protected trademark of Disney. And after watching the first couple episodes of the Agents of S.H.I.E.L.D., I kind of wish he stayed dead. But that is a protected trademark of Disney. Of course, one of the most famous ones, "May the Force be with you." Such a short, iconic phrase, it's gained symbolism. Everybody knows what it's associated with. So again, back to my loneliness and searching the trademark office, I found this phrase, which really I couldn't even understand at all. But it's, "Let's face it, poop stinks." I don't even remember how I found that one. God knows what I was searching. But this is an actual trademark. That's a registered trademark that was used. It actually is dead now, but it was used in association with doggy cleanup bags. And there was this little image. This is Dr. A.W. Poor, Dr. Awkward. Actually, the Dr. Poop. I have no clue why this was ever trademarked, but it was. It's no longer a live trademark, but there you go. So there are several important reasons to register your trademark, and some of them are very similar. You could register your trademarks on the state and federal level. There really is no reason to register on the state level unless you have a problem with counterfeiting, which is really not what we're going to talk about today. But you do it federally. It's critical in all U.S. enforcement efforts. It's not necessary, unlike copyright, to have a trademark to register to go ahead and sue somebody. But it's a very important evidence. And what it goes back to is, customs. Again, customs, the same thing as I talked about with the jewelry. If somebody comes in with stuff bearing your trademarks that's not legal goods, that's counterfeit, you could stop that. Prima facie evidence. Again, everything in that trademark registration is taken as true. So it's taken as true that you were the first person to use this trademark. You have nationwide priority over this. So what this means is if you have a store here, the comic book store that you open, you call it a certain name, somebody else wants to open a store like that in LA, you have certain rights. You could stop people from using your trademark because they're not associated with you. You could stop people from using your trademark. It serves as a deterrent. When somebody comes to me and wants to register a trademark, the first thing I do is go on to the USPTO website, which is working. So what does that tell you? It tells you that trademarks are a lot more valuable than copyrights in the government's eyes for some reason. But you go on that website, and the first thing, if I see somebody has a registered trademark, of course you don't tell your client to do it. And finally, it's a prerequisite to obtain certain damages and attorney's fees. If you've run into counterfeiting, we all know what that is, but damages go up to $2 million per counterfeited trademark, and you can only get those if you have a registered trademark. So it's very important to do that. Now, how do you register your trademark? And this is the only time I'm going to say this. I really recommend you hire an attorney to do so. And it's an easy thing if you know what you're doing. I know certain people have done it themselves and been successful, but I know a lot of people haven't, and here are some of the reasons why. It costs $375 per class. Now, that's pretty expensive, way more expensive than $35 to register a copyright. $375? Comic books are not in the same class as shirts, or not in the same class as a lot of other things. So everything's in a different class, and if you're registering, you have to pay $375 per class. So it gets incredibly expensive. Unlike copyrights, they're published for opposition. That means that if somebody doesn't like your trademark or thinks it's confusingly similar to their own, that it's going to be out there and people are going to look at it. And if you try to register something called Spider Guy, you better believe that the Marvel is going to come after you and say, hey, that's confusingly similar to Spider-Man. Not only can they oppose it, but they could also sue you as well. So if you're going to go ahead and register your trademark, I really recommend you have somebody know it. And that's why, because it's likely going to be rejected. The first time you do it, it happens probably 9 times out of 10. The trademark office opposes, and it's called an office action. And they say, well, we don't think you should register your trademark. And you're going to have to make legal and factual arguments. That is not always the easiest things to do of why you should get your trademark. And the tough one is you must show that nobody else in the country is using your trademark. If you go and register your trademark, they make you sign something under penalty of perjury that says nobody else is using your trademark. This is more than just doing a Google search, but sometimes you have to go to where I've looked at local telephone books to see if people are using a trademark. That's how specific they want it to be. Now, quick reminders, and there's a quick reminder of something that came up in the licensing panel. I saw Chester in here before. Where is he? Hey. So Chester asked a great question, which really nobody had an answer for you, so I'm going to answer it now. When do you register your trademarks? My recommendation is you register your trademarks when you are sure about your business. If you are committed to something, if you're ready to pay that $325 per class and you're ready to go out with your trademark, whether it be in a comic book or something else, that's when you do it. You do it before you get to the licensing people because they want to know you have all your stuff in order before you get to them. Because if they get sued, they're going to come after you to get sued. So that's my first little tip. When you register your trademark, when you're sure about it. Trademarks can last forever. Unlike copyright registrations, they never expire. As long as you renew them, they don't fall into the public domain. So you can keep registering. You can register before or after. A lot of people now, and you'll see it with movies and titles to movies, that's how a lot of leaked titles come out, is because there's a registration with an intent to use. So if you know you have a big product and before anybody gets out there, you can register your trademark with an intent to use registration. Use distinctive names for your characters. And this is what I tell all my comic book character clients. If they're producing characters, if you have stories, do something like Tolkien and Lucas did. Create your own worlds. Do not use names. Do not use products that we all know about. You're running into problems with other people's trademarks, but also it gives you the right to create trademarks of your own. And finally, be prepared to be rejected, much like me during sci-fi speed dating. It's gonna happen. You know, the trademark office has people that just sit there and it's their job to object to things. So there's a chance that it's gonna be rejected. It's not necessarily a bad sign, you can fight it, but just be prepared for it. Now, here are some things that I want to tell you about, and these are things you want to avoid. Things you could do, and things you shouldn't do, and things that would get you sued. the first thing we're talking about is copyright infringement. And everybody knows what copyright infringement is. We all know it as kind of plagiarism or copying somebody else. But it's when you violate one of those exclusive rights that we talked about earlier. If you violate any of those rights, that's when you commit copyright infringement. Now there's the defense, which is fair use. And fair use is also known as parody, and we see this a lot. But there's a 4-factor test in copyright infringement. The first thing you look at is what is the purpose and character of your use? What are you doing with it? Are you doing something, are you making a comment about society? Are you doing something artistic? Why are you using somebody else's work? The second thing, what is the nature of the copyrighted work? Something that's fictional is more likely to be protected than a work of history. If your story is about World War II, and that's a factual story, it's less likely to be protected as an original work, like Harry Potter or something like that. What you use and what is the really substantiality of how you do it. So if you go on YouTube and you put up a 10-minute clip of a TV show, 10 minutes out of a 30-minute show might be a little bit too much. If you put up a 10-second clip, it might be fair use. However, if that portion you pick up spoils a movie and puts it up on YouTube, that's more likely to be considered not fair use. And finally, what are the effects on the potential market? If your product is replacing somebody else's, if you are taking Spider-Man and putting it on a t-shirt, somebody else, you're taking away from Marvel's right to sell that. So those are the 4 factors a court looks at, and here's the thing. There's no right or wrong answer when it comes to fair use. There's no black and white, it's all gray. It depends on whoever makes the decision that day. But those are some of the things you'll look at. Now, the test in whether you copied somebody else is really the substantial similarity test. And my favorite case is the Superman case in Wonder Man. Detective Comics came out with Superman, and then there was another character that came along called Wonder Man. And the court looked at it and said the only difference between the 2 characters was one was in a blue costume, one was in a red. We all know that superheroes have overlapping powers, but the court in this case said it's so substantially similar to the stories that Wonder Comics and Wonder Man was put out of business. This is a case that came out this year, Mecha Hopzilla, much like Mecha Godzilla, but guess what? They didn't have permission to do that. And now Toyo is now suing the company that's doing that. That's a beer that's out of New Orleans. They didn't have permission to reproduce that and put it on their beer. So that's a case that's pending right now. Costumes, and everybody knows it's really okay to wear a costume. Yes, okay, you put on a costume, that's fair use, of course. However, what happened here on the left is this company started selling all these copyright protected goods, and they didn't have permission. And so about everybody that you could see, every trademark, every copyright that was taken, sued them all in one shot. So is it okay to wear a costume? Is it okay to create a costume for your own use? Sure. If you go on the internet, start selling hundreds and thousands of them, you're going to get into big problems. That's the line between infringement and fair use. This was a case from a couple years ago, and I just like the picture. That's why it's fun. So Naked Gun, for their last movie, actually took the exact photo of Demi Moore on Vanity Fair and replaced it with Leslie Nielsen's head. It was the exact same photo, but they just put Leslie Nielsen on it. The court actually said that's fair use. It was parody. It was a joke. It's not replacing the actual. If anybody wants Demi Moore on the cover, they're not going to go see the Leslie Nielsen movie. It just didn't make sense. So therefore, that was considered fair use. So you have the right to display things. And of course this comes to when you have rights to hang up things in the gallery. But the big question that I do get a lot is all that artist alley stuff. If you go ahead and draw a Spider-Man on your wall at home, you're probably covered under fair use. However, if you're in the business of doing so, if you put a protected copyright and associate it with your business, that's less likely to look like fair use than it would be if you just did something for yourself. If there's a business aspect of what you do, it's less likely to be considered fair use. So you have the right to perform it digitally, like I talked about, and this is the world's biggest problem, which is YouTube for copyright owners, is if somebody can take your work and put it on YouTube. Here's the question. Yeah, you can, and yeah, you can't. And you go into that little test. So really, YouTube really walks the line of what they can do with your work. Can they put 10 seconds of an hour and a half movie? Sure. Can they put the whole hour and a half movie up? No, they can't. So that's a fine line with copyright infringement and fair use, things like YouTube. Now we'll talk a little bit about trademark infringement. And trademark infringement occurs when you violate the trademark rights. We'll talk a little bit about straight infringement and tarnishment. And then there's the fair use defense here. This is a very big, complicated test that is way above what we should be talking about today. It's not like the 4 factors. But so you get my rule of thumb. My rule of thumb says use no more of the trademark than necessary and don't do anything bad with it. If you have a comic book and you want your character to drink Coke, that's fine. If you want your character to drink Coke, then kill people, that's borderline not good. It's considered more tarnishment. You're saying something bad about their product and you don't have permission to use their names. So that's my rule of thumb. The test here in trademark use is whether something is confusingly similar. It was substantially similar in copyright infringement. Now the test here is whether it's something confusingly similar. So we looked earlier, Mario is a protected trademark. We saw that little black and white thing. And here's Marco, the pasta guy. Marco the pasta guy is not an authorized reproduction of the Mario trademark. And of course, many kids running up would think that was Mario, but it's not. That's exactly what confusingly similar is. That's why something like that is not permitted. The naked cowboy. The guy in Times Square who stands with the tourists to take photos and is not really naked, so I don't know why he's called the naked cowboy. But he is actually have a protected trademark on his name, the naked cowboy, and he's been successful in some cases, not in other ones. But one big thing that's brewing now is, I'm sorry for this, is the naked cowgirl. The naked cowgirl has tried to register the trademark for her name, the naked cowgirl. However, the naked cowboy is opposing, saying that it's confusingly similar, saying you might associate the naked cowgirl with the naked cowboy. I don't know, I just think they should just put on pants. So here's the Empire State Building. It's a protected copyright and trademark. There it is, that's actually what's protected. However, how do you draw a skyline of New York? How do you do anything without having the Empire State Building in the background? You really can't. So it's fair use. As long as it's really not the focus of it. It's something like Independence Day where you blow up the Empire State Building. Maybe something like that you would need permission for, but if it's in the background, if you take a photo, it's in the background, that's more likely not considered fair use. Now, tarnishment. Tarnishment is when you take a trademark and you do something bad to it. This was the poster for Friday the 13th, Jason Takes Manhattan, that never made it. Because that I Heart New York, that's a protected trademark. And New York didn't want to associate itself with Jason and a bad movie. So this was considered tarnishment. So therefore, this was considered tarnishment. It's trademark infringement. That poster actually never got released. It was stopped. Victoria's Secret had a little problem with Victor's Little Secret. And most of these tarnishment cases always go back to porn. Victor's Little Secret was a porn store, and Victoria's Secret objected because we know that's upstanding, fine clothes. And they wouldn't want their name associated with that. And guess what? They won. They thought that people would it was confusingly similar, that you were taking their trademark and doing something bad to it. This was a case that came out this year. Ben & Jerry's is a protected trademark. Somebody decided to make a line of porn, and I told you all, it was back to porn. Ben & Jerry's and coconut 7-layer cake. I get it, it's funny. The court actually decided that they're doing something bad. You know, ice cream is very wholesome. So associating itself with porn is not a good thing. So that's what happens there. That was considered tarnishment. Now, fair use, okay, let's say you take the kids to Sesame Street and give them cigarettes and guns. All right, you're doing something bad to trademark, but maybe you're making a comment about society. Maybe this is something artistic. If you can make that argument, then that's considered fair use. That's considered parody. We see this all on The Family Guy and The Simpsons. We see things like this, where they use copyrights and trademarks, but they're doing so to make a statement about something. So we consider that fair use. We're almost done, and I'm going to talk quickly here, but if you want to protect your IP, there are some things you need to do. The first thing is, if somebody is using your work, it is your responsibility to stop it. Nobody else in the world is going to do it because nobody else has the responsibility to do it. So if somebody uses your work, hurry up and send out a cease and desist letter. And that one in green, that's actually one that was taken from somebody who just did it himself and send out trademark infringement. That's all it takes. Send out things like that. And you all get those little screens in the top right when somebody's taken down on copyright. It's because somebody objected to something that was on YouTube. So it's your responsibility to protect your own IP. Nobody else is going to do it for you. If somebody's doing something good with your trademarks and copyrights, and this is like a lot of settlements to cases, just license them. We could always license people if they're doing something good with your work. So maybe they are, maybe they're not permitted, but maybe you can work out a deal with them. And finally, cases you might have to sue the infringer. This is always the worst case scenario because everybody knows the uncertainty of litigation. But it's some chances that some things that come up that somebody rips off your work that you're going to have to sue them. Work for hire agreements, just real fast because we're running late. I'm running late. Work for hire agreements, if you have somebody that's working on your comic book or something like that, please get a work for hire agreement before they start work. You can't do a retroactive work for hire agreement. And I've been in situations before where I'm trying to negotiate something after the fact where everybody sat down with their friends and said, oh, this is all great, we're working on a comic book together. Then all of a sudden money starts getting involved and people get greedy. So if you have somebody that you have a story, you want to farm out the actual illustrations or something like that, get a work for hire agreement. Do so before then. It's automatic if you work for a corporation, if you work for Marvel, and everything done during your regular 9-to-5 day is considered work for hire. Stuff done off the clock isn't. So those are some of the quick pointers, and now it's your turn to ask questions. And so we'll open the floor up to some questions. And I saw you first. Go ahead. You mean, like, would somebody ask you to draw something? Yeah, no, that's legal. That's more not like, that's kind of like a work for hire situation. But something like that, if you do want somebody to do something, it has to be in writing. So anything work for hire, you want somebody else to do your work, it has to be in writing. Yeah. Absolutely. Yeah, definitely. And one big thing that I like to tell people is a lot of people like to put out their work out to the public and let other people make comments about it. It's very risky. Unless you have some kind of agreement when you go on a website, a lot of them do have websites where you say, anything that's added is not yours. But you want to be careful. You don't want ever people come back and claim they created something you created. So that's the biggest risk there. Okay. Yes, and it goes by what country it is. There's something called the Berne Convention in copyright, where we recognize the copyrights of a lot of other countries around the world, and they recognize ours. So yes, there are international implications that you do have to worry about. Okay. Yeah. No, as long as it's not substantially different, you don't have to. There's also something called a pre-registration you could do before you're ready to finalize something. But it's always best to wait till the end to be sure. If you make small changes, no, you're still protected because that's really the same thing. And what you do is file an amendment where you could change the actual work that's protected. Yeah. Mm-hmm. You could, since it's coming out of a company, do you know?
What happens to the name?
Yeah.
The name goes back up for grabs, but not if it's trademark, because that's forever, so.
Yeah, and what you can do is, it's be part of this, when you dissolve the company, you could sell out those rights again, so you could sell those right back to the person who was. And that happens oftentimes in bankruptcy. When places go bankrupt, they sell off all those rights. It happened with Twinkies, with Hostess, so things like that. Always do. Yeah. No, you don't have to file anything. Whoever you want to own the copyright trademark, they can own it. What you should really do is if you're dealing with other companies, even if they're in the same branch, you should license them. So you give them the license to do so. Mm-hmm. No, if it's yours, you're pretty much protected. It could be any type of.
You guys repeat the questions?
Okay. Yeah. It was a complicated question. So the question is whether if you have a big, I guess, conglomerate of companies, whether who owns a copyright, who's a trademark, and whether the smaller companies, if they produce the T-shirts, who should actually protect it. So my answer is probably the biggest company you have, but then you license the other ones. And now the question was, does it matter if it's a corporation or LLC? No, it doesn't. It's the same thing. Okay? Yeah.
Can you copyright a treatment for a movie or a television?
Absolutely.
I make animatronics, copyright motions, as well as like static physical designs.
That's a great question because there was a big lawsuit just about yoga movements and whether yoga movements could be protected as copyright. The answer was no. But yes, I think in certain ways you can protect certain, if they're very specific, certain dance moves, things like that. I think they can be protected.
It's a large sequence.
A large sequence, yes, I think you can protect it. Yeah, sure.
Can a parody of a copyrighted work itself be copyrighted?
Sorry.
Yeah, she's asking if a parody of a copyrighted work in itself be copyrighted.
Oh, that's a tough one.
Like an episode of Family Guy.
And that's exactly what I was going to say. An episode of Family Guy is protected under copyright. But if what's not protected is your use, if somebody else uses the characters, you can't go after them. If somebody parodies your parody, you can't sue them. So it's all parody.
This is slightly off subject. In your practice areas, do you both have LLMs or do you do intact? Because I do things, and I just hearing what you do is a lot more interesting than I do. But I didn't know how much interplay between what you do or what you did to get into that area.
Well, Michael just, I don't know, you've been doing this for years.
Yeah. No, not too many. No, I don't have an LLM. I just have a law degree, but I've just been in IP before I even went to law school. So it's just kind of something I stumbled into out of college, and something I'm still stumbling in every day. So, yeah.
If your work is digital, like if I have a comic book and all the pages are digital, can I copyright the digital copies of the pages without an actual print book?
Yeah, absolutely. The copyright, it's hard, so you could give them whatever form is something that, as long as it could be permanently recorded on something, then that's what you can submit to the Copyright Office. And like things like source code, if there are certain trade secrets in your source code that you don't want anybody knowing about, you don't have to produce all hundreds of pages of source code. They want sometimes the first 10 and the last 10 of your source code, and I've done that before, so, yeah.
About 13 years ago, there's a shirt that came out, Kermit Klein, I don't know if you guys are familiar with it. It's Kermit the Frog wearing jeans and the underwear showing up and it says Kermit Klein.
Okay.
In that situation, it's a parody,
Yes.
but you're selling the image of Kermit the Frog, and you're also selling the image of Calvin Klein.
Mm-hmm.
So how does that work?
No, and that's when you looked at that 4-factor test that we talked about in fair use. So I can't give you an answer of whether that is copyright infringement or it would be, the defense would be fair use. It's up to the judge or jury whoever makes the decision on that day when balancing those 4 factors. And those 4 factors, one doesn't have more importance than the other. So it's balanced out. And like I said, it's gray, and it's very hard to advise people of whether they're okay or not. So it's a tough choice, but there is no right or wrong answer. Yeah.
I'm helping launch a business plan competition at my college. A lot of these students already have solid ideas or already have started their businesses. Besides trademarking and copywriting, what other advice would you have for these students that are looking to enter the competition?
I guess what we talked about, obviously you said they already started a business. If they haven't formed an entity, they should be forming an entity. They should, I mean, it totally depends on what kind of business they have. So
So I had a two-part question about copyrights or webcomics. The first is what should you make sure to copyright in the images and then maybe a transfer of the dialogue, but the answer you're saying. And the second part is how often should you, or how do you deal with it? Because if you have webcomics coming out, say weekly, I don't want to be paying $35 every week, so should I like bundle it up?
Yeah, and that's what I talked about earlier. It's absolutely bundle. First of all, the thing that I would protect is at the best copy, they want the best copy you could get. So if you could print out a copy of your actual webcomic, that would be great with the dialogue. But yeah, wait till you do a whole bunch. So you have a whole bunch, do it in one shot, call it a series. You could put 200, a whole year worth on one series on one copyright registration. So.
And it's okay to do it after the fact?
Yes, yeah, it's okay. I would do it as soon as possible. Okay, yeah.
So, this is sort of specific, I'm sorry,
So much.
So I have a blog called Project Reroll, and it's all about like using nerdy stuff to inspire you to go after your own goals, go after being more fit. And a lot of it includes like cosplay goals, where you're like obviously taking on a trademarked entity if it's a character that's created in a comic book or a movie. And then I also have like recipes that are like baked eggs in an avocado TARDIS because it's bigger on the inside. Like I've been asked about possibly creating like even just a recipe book about that stuff. And while that sounds awesome, like I did not create. While I created the recipe for that, I did not.
How about this? Recipes aren't protected under copyright.
Ah.
Lists, certain things like lists, phone book listings, not protected under copyright. So, okay, so we are done. Thank you everybody for coming. We'll be here. I have business cards. I have law firm propaganda if you want it. And we'll here for questions. Before they kick us out, we'll be outside to answer any questions you have. So please come up and ask.